We're here today to hear about two important and consequential and linked subjects: the role of the courts in our lives here in Florida and gerrymandering. These Why Courts Matter presentations, and I think we've done somewhere between 7 and 9 of them, are designed to make you aware of how important federal courts are and how they affect you, the Florida citizen, and why it is so important to have good judges in our federal courts. These presentations have been brought to you by a generous grant from Progress Florida Education Institute. We have done a lot of these, and we've seen a lot of reaction. People start looking at issues differently. So why are we talking about gerrymandering in Florida today, though? Didn't we get this done already? We have fought a long fight. Pam Goodman said 40 years, fair districts in the courts, and we have redistricted most of Florida. But this year, the Supreme Court was faced with two monumental partisan gerrymandering cases, and they punted. They didn't come up with clear rulings. They let the decisions go back to lower courts. We're currently all listening to the hearings on the new Supreme Court, for the Supreme Court opening, and we're worried. And today we're in a very hyperactive political environment where voting rights is top of the endangered list. So we got the right speaker, let me tell you. Tom Wolfe is with the Brennan Center for Justice at NYU Law School in New York. And he is Brennan's expert on gerrymandering. I can't tell you how much I think of Brennan. Brennan was one of the first resources and definitely the best resource for wonderful, straight, knowledgeable, accurate information on voting rights issues. Tom is supremely qualified to talk about this, and he's a thoughtful professional. He's also optimistic. Tom?
Thanks to the League and to Nancy for bringing me down and hosting me this weekend. Thanks also for taking some time out of your Saturday morning to come out here or log into Facebook and watch what's going on. As Nancy said, I'm Tom Wolfe. I'm an attorney with the Brennan Center. I focus mainly on partisan gerrymandering, particularly partisan gerrymandering litigation in the federal courts. And I also do a bit of work now around protecting the 2020 census. But we're here today to talk about gerrymandering, at least in the first instance. So, I'm not sure if I can say this right after Labor Day, but fall is in the air. And you know, what that means is we get to spend some time looking forward to engaging in many of our traditional American holidays and pastimes like Halloween and Thanksgiving and voting under extremely gerrymandered maps. Earlier this year, many people, myself included, were hopeful that the Supreme Court was going to step in here and restore some sanity to our elections when it had the opportunity to rule in two very important partisan gerrymandering cases. And the sunny background here is reflective of optimism. Our reality is a little darker, a little cloudier than that. The rulings that we were hoping to get did not come to pass. Instead, the rulings for the plaintiffs that might have helped us all around the country move things forward a bit on the gerrymandering front, the court took a pass and sent both of these cases, both the Wisconsin case and the Maryland case, back down to the lower courts for more proceedings. It would be a massive understatement to call this a massive letdown. We were very hopeful that we could finally break through here, and it didn't happen. why are we concerned about this? Partisan gerrymandering has hit extreme levels this decade as politicians use the remapping process in 2011 to manipulate district lines to maximize their party seats, to lock those seats in, and then lock their opponents out of elected office. And the courts, and especially the Supreme Court, are not solely responsible for this happening, but they've contributed heavily to it, and they're going to play a very important role in pushing back at it if we're going to have any hope of really getting traction here. We're talking about the courts, but key for today is that as much as you can talk about what's going on in this kind of marble temple on a hilltop in Washington, D.C., what happens here affects all of us. And the main way it's affecting us right now is when we turn out to vote, whether we can actually get legislatures that represent the true views of the people who are voting for them, and whether we can hold our representatives accountable when they deviate from what we want. So as long as we are not getting firm guidance here, we're going to have problems having an electoral system that's both representative and accountable to us. So my presentation today is going to have mainly three parts. I'm going to spend about 45 minutes over this session that's going to explain how the federal courts, and particularly the U.S. Supreme Court, are affecting our ability to have fair maps. And I'll take you through basically three parts here. The first part is talking a little bit more about the problem of extreme gerrymandering, which is sort of the basis of everything we're talking about today. The second is reviewing the past, the present, and the future of the Supreme Court's attempts to, or near misses in its attempts to put some limits on the practice. And then the third is to talk a little bit more at the end about some of the bigger political context here that I hope will leave you feeling both better informed, but also maybe a little bit more empowered when it comes to tackling this problem. It's a serious issue, and I think sometimes it can leave folks feeling a little dispirited. That's definitely not the way I want you to feel at the end of the day today. So hopefully we'll be able to map out a couple different places where progress is being made, and folks can continue working. So, the problem, extreme partisan gerrymandering. And whenever you're talking about gerrymandering, it's very important in the first instance to define your terms. Because the term partisan gerrymandering has become sort of a catch-all for everything that people have problems with when it comes to our maps, our legislatures, our legislators. When people say gerrymandering, sometimes they mean weirdly shaped districts. Sometimes they mean they don't like incumbent protection. Sometimes they're talking about just a dysfunctional legislature in general. One of the challenges with trying to move the Supreme Court in a positive direction on all of this has been to try to get it to narrow its focus and pay attention to a major but one aspect of the problem. A lot of the court cases that have been making headlines over the past 2 years, including the one in North Carolina that's going to be coming up, will probably be argued sometime this winter, involve what we're calling extreme partisan gerrymandering. Extreme partisan gerrymandering, as this kind of faux dictionary definition outlines, is a tactic where one party uses the redistricting process to maximize its seats and lock those seats in, basically for the whole duration of the time that map is in place, so basically 10 years immediately following the census. What this ends up meaning is that it ends up becoming a tactic for creating a legislature that looks a certain way in terms of its partisan makeup, basically regardless of how voters actually vote. That's a little bit of an exaggeration, because if you were able to turn out 70% of voters to vote for one candidate, you may be able to break a gerrymander. But when you're talking about what happens realistically in the course of American elections, you basically see these maps that have been scientifically engineered to withstand any reasonable shift in the way voters vote. The key to all of this is that when you're talking about gerrymandering in this way, the main thing that you are focusing on is the way a map converts votes that voters are casting into the seats that the parties hold. So the districts may be perfectly square, or they may look like Donald Duck kicking Goofy was probably the most famous one from Pennsylvania. the shapes really don't matter. What matters more, and is going to matter more as map makers learn more and more how to create districts that are slanted but normal looking, is that ultimately what happens is one party gets more seats, even if it doesn't get with the same number of votes. So an example would be if Republicans get 52% of the seats, they get 52% of the votes, they get 65% of the seats. If Democrats in a given map would get 52% of the votes, they would only get 48% of the seats. That's kind of the core issue there. The maps have been changed so that no matter how many votes one party is pouring into an election, they can't really change the way the seats are ultimately distributed. I have a few graphs that I think explain that a little bit more graphically. So let's talk about a concrete example. North Carolina, I know that we're in Florida, but North Carolina is what you're going to be hearing about most between now and June of next year. It's the next case that the Supreme Court's likely to take. It's likely to happen this winter. So just to get some of the context in North Carolina in place, because it helps you understand exactly why extreme gerrymanders are happening. So 2008, North Carolina, Barack Obama is elected president. One of the states he wins is North Carolina. North Carolina Republicans start to freak out a little bit about their political future. There's all this talk in the papers about this new Obama coalition that's going to make the Republican Party obsolete. So while all that's going on, around the country, there's this sort of Tea Party insurgents, and on the back of that, in North Carolina and a lot of other states in 2010, Republicans not only take back legislatures, but they get a relatively large number of seats in those legislatures. Extreme gerrymanders like North Carolina don't happen everywhere. There were about 6 maps this cycle where there was some kind of extreme partisan bias. That's under social science measurements that I could talk about later, but they're kind of not the whole story here. But when you run those analyses, you find that there are about half a dozen really bad congressional maps. And then there are about a dozen state maps that also have high partisan bias. The thing is, even though these extreme gerrymanders don't happen everywhere, where they do, they have very negative effects. So it kind of starts at the beginning of the political process and then works its way all the way through. So you've got these legislators who realize that they can get a huge bonus to their party if they fight really hard to gerrymander their maps. So they're at each other's throats during the redistricting process to get as many seats as they possibly can and try to stop the other party from doing that. By the time the maps are passed, everyone hates each other, and then they can't get actual legislation done for the next 2 years of their session or 4 years of their session. It cements in these majorities that voters cannot vote out of office, no matter how hard they try. It creates these legislatures that are either hard left or hard right in states that are kind of purple. So North Carolina, again, is another kind of systemic example of this, where you had all this commotion over like the bathroom bill a couple of years ago, where it didn't really seem like it had a constituency outside of the legislature itself. And that's partially due to gerrymandering of the state legislative districts, too, to create these kind of hard right majorities. And then, when map makers are intentionally using the way people vote to engineer these districts, they're violating our rights under the Constitution, the First Amendment, the 14th Amendment, Article 1. So whether you're talking about high constitutional rights or whether you're just talking about people getting stuff done, it basically doesn't happen when you have extreme partisan gerrymanders. And then you can do a little statistical analysis to see exactly what we're talking about. Earlier I was talking about this concept of translating seats to votes and everything like that. These are North Carolina's maps. The 2012 map is in light blue. The current map is in dark blue. We don't know how much longer that's going to be the map, because that map's now been declared unconstitutional twice, and now it's being reviewed by the Supreme Court. But basically the way gerrymanders work is this range in here is the range of vote distributions in normal elections. So North Carolina, it's usually somewhere between 45% Democratic and 55% Democratic, or vice versa, Republican. that's the kind of band where you would normally expect to see election returns. And what they do is they create these maps so that you've got a couple of Democratic seats over here that are hyper-packed. There are tons of Democrats in these 3 districts. That's your 3 and the 10 to 3. And then the other 10 Republican districts are arranged kind of right along the edge of what's kind of normal and possible. And you'll see that the most Democratic district isn't nearly as, or the most Republican district is not nearly as Republican as the most Democratic district is Democratic. So you basically pack your rival party into a small number of districts, and then you spread your supporters out so that you're winning a large number of seats, but by not a very large margin. And they're always paying attention to what is kind of normally expected because they don't want to lose their seats. So they kind of arrange it very, very, it's kind of like a razor's edge approach to this. The flat part in here is showing you an extremely unaccountable legislature. Because what it means is, for instance, in North Carolina, whether Democrats are getting 23% of the statewide vote share or 55% of the statewide vote share, they're not picking up more than an additional 2 seats. And they need to swing the vote roughly from 25 to 52 in order just to pick up 1. So we're talking about like huge changes in the way people are voting, and it's not changing the map at all. You'll also notice that these 2 maps have basically the same curve because you just took the light blue racial gerrymander and you turned it into a dark blue partisan gerrymander. They're basically the same map. The lines might be different, the districts may look a little different, but when it actually comes to producing a legislature, it's basically the same thing. Not all maps look like this. So this is the map for, or the California's map from last decade and its current map. And you'll see the light blue older map has that same kind of flat thing in the middle where, kind of even as you're increasing votes, you're not picking up any more seats. The dark blue line is basically, it's basically a diagonal line. So the more votes you get, the more seats you get. The reason why these maps look different is that between the light blue map and the dark blue map, California got its independent redistricting commission. And they allowed lay people, not politicians, to draw the maps for the state. It was a resource-intensive process, but the result of it was a map that is fairer, basically, on all dimensions. It's more responsive, that makes it more accountable. It looks more like, it produced a legislature that looks more like the legislative, or the people of California. So, social science kind of helps us see these things in action, but practically what we're speaking about is just creating maps where you can't shift seats. Florida's map, this is the 2016 map. It also is more or less diagonal. We don't have the line plotted on it, but instead of having a big flat part in the middle, it is basically diagonal. It does, though, still have a little bit of the kind of flatness on the tail end on both sides. What that's reflecting is probably something that many folks here already know. There was a gerrymandered map at the beginning of the decade. The court ended up coming in and imposing a new map where the districts in southern Florida were redrawn using a map that was suggested by the League in Common Cause. That made the map somewhat fairer, but it still has like vestiges of being a political gerrymander because it wasn't completely remade. The Florida map is kind of caught in the middle. It's definitely much better than the North Carolina map. It still has traces of the unfairness that were basically rooted out in California. There's traces here on the tail ends. But for the most part, it's looking pretty good. All right. This is all scripted, by the way. Like I have in here, it's like gesture ineffectually at screen. So good. It's all. I like when my plans come together. So earlier I was talking about extreme partisan gerrymandering as a tactic, and I mean that in sort of a sense that it is part of like a political toolkit. It's something that you can deploy to advance a strategy. The thing is, when gerrymandering of this extreme kind was happening at the beginning of the decade, not everyone knew about this tactic. It was something that is kind of the result of some new advances in social science. And then it's just some basic stuff like computers have gotten faster and we have more data about how voters vote, so we can actually start crunching all of that voter data to fiddle with our maps some more. Karl Rove got very psyched about this and maybe showed his hand a little bit. He wrote an op-ed in the Wall Street Journal basically while all this extreme gerrymandering was happening, telling everyone that they were extremely gerrymandering, and I'm not sure that like the message was fully heard. But the difficulty is now that we've seen all of this, everyone knows how to do this. And it's not necessarily all that complicated. So we now have this system where we have maps that create these artificial majorities. They lock them in a way that's really durable and very hard to dislodge on the basis of things that were 6 or 7 years ago in comparison to now kind of rudimentary. So the computers have gotten faster, we've gotten more data on voters, we now have the ability to create billions of alternative maps and then evaluate them for any number of different criteria that you might be interested in, and then pick the one that is maximizing that criteria. So now it's entirely possible to tell the computer, generate a map for North Carolina that has a 10-3 advantage with districts that are entirely compact. And then they can generate, 75 different versions of that map that would allow you to get an extreme gerrymander just like the one we currently see in North Carolina without any districts that kind of look strange. And that means that it's going to get harder to kind of do the eyeball test on maps and identify when they're bad. The other thing is that the groups that are doing that are invested in redistricting on either side of the aisle are now going to be pouring huge amounts of money into all the legislative races that are happening now, the gubernatorial races that are happening now, all of which are slowly, kind of election by election, putting the people in place in the state houses and the governor's mansions that are going to control redistricting in 2021. So if you don't like money in politics, it's going to get worse because the stakes for winning elections are going up. Even in Florida now, the stakes for the gubernatorial election are going up because whoever is elected governor is going to have the opportunity to place, I think, up to 4 justices on the state Supreme Court. And it was the state Supreme Court that was instrumental in getting the ruling that was able to remake Florida's map. So the stakes are getting very high. The politics are going to get much rougher. There's going to be a lot more money involved. And that's all, from my opinion, and you probably agree with me on this, generally very bad for our politics. So things have gotten bad because of technology and data, but it's not just computers that are contributing to all of this. The U.S. Supreme Court has also contributed significantly to the situation that we're experiencing now, because it has been spending more than 30 years trying to figure out what to do about this issue and not reaching any firm conclusions. And in the absence of a red light from the Supreme Court saying you can't gerrymander, gerrymanders are taking that as a green light to go do what they want. And North Carolina, again, is the most flagrant example where the court says you can't do that, that's an unconstitutional racial gerrymander. Someone turns around and says, fine, I'll just do a partisan gerrymander and you can't stop me because that is not unconstitutional. That's almost a direct quote. So there are people that are walking around feeling very empowered by the absence of a Supreme Court ruling here. The very strange thing about partisan gerrymandering as a Supreme Court issue is that basically most justices over the last 30 years who've weighed in on this, regardless of where they are on the ideological spectrum, agree that partisan gerrymandering, at least in its extreme forms, is unconstitutional. But they haven't come out with a rule that helps us determine when a map is unconstitutional and when it's not. So that raises a lot of questions for attorneys or constitutional scholars, like why is the court so locked up on this, and how did it allow things to get to this point? The court's taken a couple swipes at this issue, both historically and now even over the course of the summer, and none of them have helped plaintiffs. So how did we get here? I won't get into all the details, but here are kind of the headlines from these cases. In Davis, the Supreme Court said that partisan gerrymandering is unconstitutional, and a majority of the justices agreed that these are the kinds of claims that what the justices call justiciable, which basically means the kinds of claims that courts can hear and decide. But when they created the standard for determining when a gerrymander actually happened, they put the bar so incredibly high that for the next 2 decades, no plaintiffs were ever actually able to get a map struck down as an unconstitutional partisan gerrymander. The standard was basically asking people to say, to demonstrate in the words of the court, that the electoral system was arranged in a manner that will consistently degrade a voter's or a group of voters' influence on the political process as a whole. I don't know what that means. No one knows what that means. No one's been able to figure it out. So we went 20 years and no plaintiffs won. The court took another pass in the mid-2000s in Vieth. 20 years passed, of course, so the composition of the court changed a lot. What came out of this case was something we normally call a radically fractured opinion. So there were 4 justices led by Justice Scalia who said, actually, partisan gerrymandering claims are not justiciable. So they wanted to take the court and move it a step back and say you shouldn't even hear these cases at all. There were 4 justices that said, no, these are totally cases that the court should hear. Those 4 justices could not agree, though, on what the rule should be for determining when a map's unconstitutional. So there were 4 justices, 3 different rules. With no agreement, there was no rule. And then Justice Anthony Kennedy was trapped in the middle of these 2 blocks of 4. And what he said was, I think partisan gerrymandering is unconstitutional. I'm not ready to close the door on courts getting involved here, but I don't know what courts should do when they get involved. So I'm not agreeing with either side, and we'll let these cases keep going while we all try to figure out what's happening here. If you've been monitoring the news over the last 2 years about gerrymandering in the courts, you've probably heard Justice Kennedy, Justice Kennedy, Justice Kennedy all the time. And it's because he's the man in the middle, like almost literally in these cases. If you could convince him of something, you might be able to get then the 5 votes you need to move things forward. So Justice Kennedy released that opinion, and then like a whole generation of constitutional law professors probably got tenure, like just writing articles trying to figure out what Justice Kennedy meant. LULAC came after. It didn't really change the state of play all that much, but Justice Kennedy gave us like a little bit more of a hint about what he might like. He wanted a standard that required you to show that there was some kind of bad intent when the legislature drew the map, and that you also had to find a way through what he called a reliable standard to measure the burden on voters. So bad intent, bad effect, and this word measurement or reliable standard. Now everyone said, okay, what does that mean? And then everyone spent 10 years trying to figure that out. But we see the date here, 2005. It's the last time the court weighed in. Then that means that during these key years of 2010 and 2011, when the maps were being redrawn, the court was silent. And that set us up for everything that we just spent the prior 15 minutes talking about. You didn't have the red light from the court, and so people pushed their advantage as hard as they possibly could to create extreme gerrymanders all over the country. So why has the court been struggling? I think there have been a couple things at play here, and this isn't really a secret because the court writes about this stuff a lot in its opinions on these issues. The first is that the court is hesitant to intervene in the political process. This is actually a running theme in U.S. election law generally. Like what we've seen in the kind of post-World War II era is the Supreme Court slowly taking steps into what it calls the political thicket. And every time it does that, there's some hand-wringing amongst the justices about whether this is something that we should be interfering in, because there's a concern that they're getting involved in things that are too political. Redistricting is something that's considered maybe the most political of all things that the court could be ruling on. What does that mean? Well, it means two things. One, it's political in kind of the sense that, like any election law changes, you may change the outcome of an election by changing the way districts are drawn. Like if you couldn't do that, then no one would care about gerrymandering, because it means the lines don't matter. But the other is something about how the Supreme Court understands its role vis-a-vis Congress and state legislatures. So one of the reasons why we consider legislatures to be political is because political decisions are ones that don't have a clear answer, where you're balancing a lot of different competing objectives, and we leave it up to the legislatures to say, okay, there could be 45 different ways to balance these things. We picked this one, we got a majority of votes for that balance, so that's the one we're going with. Whereas judges, we normally rely on, they do balancing themselves, but normally we're requiring them or looking to them to impose rules, mainly rules that come from the Constitution or from their interpretations of statutes, and making decisions that way. So the court's also concerned that it may be taking on a political role that isn't really something the court should be doing. Second, the court wants to make sure that if it steps in these kinds of cases, it doesn't have to step in everywhere. There's kind of a unique feature of gerrymandering cases, which is that normally if you bring a lawsuit in federal court, you get one district court judge to try your case. You can appeal it to the circuit court, where you get a panel of 3 judges to decide the case, and then you can appeal to the Supreme Court, where 9 justices will weigh in on your case. Redistricting is different. So if you challenge a statewide map, the 3 judges hear it in the district court, and then you can appeal immediately to the Supreme Court. That then creates a situation where if the court says you can challenge these maps, they could get hundreds of challenges of maps. Like 2021 could result in all 50, well, not all 50 states, but any states that have more than 1 seat in Congress having their congressional maps challenged, and then all of the state House, state Senate maps getting challenged, and then the court will do nothing for years except decide redistricting cases. The court doesn't want that. It doesn't want a flood, so it's basically turned its case law into like the Hoover Dam of constitutional law. So this term's cases, or last term's cases, Maryland and Wisconsin, were the first time the court was going to step in since the mid-2000s and after all this extreme gerrymandering to actually set some rules. And things seem to be like perfectly set up for the justices to finally do something here. Why? Okay, so first, and maybe this is the optimist in me, the basic facts. Like things had gotten so bad that it was hard to think that someone wouldn't step in and do something this time. You had these gerrymanders around the country, particularly in Wisconsin, that were so extreme. There was no secret what was going on here. The extremity kind of amplified the stakes. It made the cases easier to decide, and it also made it seem more important for the courts to actually step up and do something. Second, the court itself. A few new justices had been added. It didn't really change the quote-unquote ideological balance of the court, but different justices have different skills, and maybe now with Justices Kagan and Sotomayor on the bench, maybe we had some additional people who could finally convince Justice Kennedy to come over and join the block with justices that wanted to do something. Third, there's all this evidence. So you had terrible evidence in places like Wisconsin about them manipulating the maps. You also had social scientists who read Justice Kennedy's opinions in the mid-2000s and said, maybe there's an empirical way of resolving this problem, and so they invested a tremendous amount of resources into developing social science tools like statistical tools, alternative mapping tools that can help you get at some of these issues. The fourth was that lower courts in the federal system were becoming increasingly supportive of plaintiffs. So up till about 2015, plaintiffs had not been winning gerrymandering cases. That changed with the Wisconsin case. The plaintiffs won there. The plaintiffs won in North Carolina. The plaintiffs won a kind of an intermediate victory in Maryland. There was also the state court victory in Pennsylvania. And then we also had slightly earlier in 2015, the Florida Supreme Court victory on the congressional map here. So you had 5 courts, including 2 state Supreme Courts, ruling for plaintiffs. And that starts to create a situation where justices who are arguing that there's no way for courts to figure out these issues start to look wrong. And it also suggests that there's kind of a wave of popular support for doing something here that may make the court feel more comfortable in finally stepping in and making a decision that still might be somewhat controversial. But we didn't get that. We got a major punt, as Nancy said. So what happened in Benesek, the Maryland case? This is Michael Kimberly, who argued for the plaintiffs. He ended up getting a ruling that said, we're not actually going to tell you anything about what the rule should be in this case, because all this case was about was whether the map should get blocked while you were appealing to us. So we're going to just say, no, there shouldn't be a new map while you're appealing and going to trial. You should just go to trial, and in the meantime, everyone should vote under the current map that you have. So Maryland could have been a major case, and it's going to end up, I think, becoming kind of a footnote in the history of the cases. Then you also had Whitford, the Wisconsin case, which is where the kind of big major opinion came out. This is Paul Smith, who was arguing for the plaintiffs in Whitford. Basically what the court did here was, in punting on the issue, it kind of delayed ruling. So what it said was, the plaintiffs in this case claimed that they had their votes diluted, meaning watered down in their districts. But when it actually came time to try the case, all they were talking about was how the Democratic Party in Wisconsin was performing at a statewide level. So they haven't proven in the first instance that these plaintiff voters were harmed in such a way that would give the court's jurisdiction to even pop up and do anything about it. So the ruling wasn't on the constitutional rule, it was on what is referred to as standing, which is basically a threshold issue. Plaintiffs have to show that they're hurt in a material way to get the court to say, okay, now we'll actually try to do something to help you. And what the court did there was to say, in order to cross that threshold, you have to make a individualized district-specific showing, which means basically you have to prove to us that your district was either cracked or packed. If you can't do that, you can't go any further. So what we're going to do is, because this case is an important case, we're going to send you back down to the trial court, and you can see if you can develop some new evidence to show that your plaintiffs were cracked or packed. Justice Kagan issued a concurrence that 3 other justices signed on to that added a little bit more analysis. She talked a little bit about how you could show that you were cracked and packed. But she also suggested that there could be another constitutional claim here under the First Amendment, where you would argue that on a statewide level, a group like a state's political party had its ability to turn votes into seats undercut. What Justice Kagan was doing in that opinion seems to be trying to convince Justice Kennedy that this First Amendment theory is the one that should be followed. She layered in all of these quotes from Justice Kennedy from his earlier opinions to kind of show, oh, well, you know, if you care about all these things, this is the way you tackle it. So we looked at that and we said, okay, this is not great, but it's not horrendous. It looks like now there's a fight going on in the court to see who can win Justice Kennedy's vote. And maybe you can kind of put a bunch of theories in play, and this is still a live issue. Justice Kennedy is still the key, and we'll just pick ourselves up, dust ourselves off, move on from here. Then Justice Kennedy retired. And good news being that now no one will have to worry anymore about what Justice Kennedy thinks on this issue because his thinking was kind of inscrutable. The downside is things have changed. So Justice Kennedy retiring and being replaced by a justice who is likely going to be much more conservative ideologically than him suggests at the very least that whatever likelihood you attach to winning a partisan gerrymandering case before has decreased. The question is, how much has it decreased? My position on this basically is it's gotten harder. I don't think that it is impossible to win these cases, but they've gotten harder. And given that we've now lost Justice Kennedy, who's the justice around whom everything was being organized, it also means that you have to do some new thinking about what new arguments might be persuasive. So if you wanted to be hopeful about the situation, these are some of the reasons to be hopeful. One is that, again, maybe this is just me striving for optimism in almost like a psychotic way, but things have gotten really bad. Things have gotten really bad. Extreme partisan gerrymandering is really bad. The second is that Chief Justice Roberts is now the swing. And there has been some thinking that he may ultimately be interested in finding some kind of ruling to curb at least the worst stuff because these cases are so political that allowing the politicians to continue winning may make the court seem more political. And so part of preserving the legitimacy of the court may be actually stepping in and dealing some blows to the parties in power to preserve people's respect for the court. Another thing is that the conservative justices in these cases didn't go as far as many people feared they would go. There was some concern that everyone would cluster around Justice Scalia's idea from the mid-2000s that we should just kick these cases out of court entirely. And there didn't seem to be much of an appetite for that. At oral argument, even Justice Alito and Chief Justice Roberts seemed troubled by some of what was going on here. So it's not clear to me that there's a kind of a reflexive desire to kick these cases out of court entirely, or at least not without thinking through this a bit more. And then another thing is we see this wave of lower courts ruling. We also see just the huge amount of popular outrage that all this is generating. This is important because if you're going to ask the courts to take a step that seems pretty radical, they need to feel comfortable that there's not going to be massive backlash. They don't like to be out in front of popular sentiment. And it seems like popular sentiment has really swung in the direction of curbing this stuff. We know from polls that a majority of voters by a very large margin, regardless of their political affiliation, want the courts to do something here. And we see the lower courts continuing to push. So in North Carolina, that case was sent back down after the two, the Maryland and the Wisconsin opinions came out. And the court said, you should reconsider what you ruled here in light of what we said in Whitford. The North Carolina court basically said, fine, took the opinion back, rewrote it, came to the exact same conclusion they came to before, and sent it back to the court. So the lower courts are very confident that they can do something here. And that should give the Supreme Court, I think, some pause, and to really tackle this seriously. Now, the reasons to be less optimistic here, it's not entirely clear that the analysis that Chief Justice Roberts laid out in his opinion is kind of the predecessor to what a claim on the merits would be. So they've basically adopted a way of thinking about a voting injury that we see a lot in Voting Rights Act litigation called vote dilution. But it's not clear that that analysis should just become the merits analysis, particularly because Chief Justice Roberts has not always been a prominent supporter of the Voting Rights Act. So it might seem a little strange to adopt that analysis and move it over here. Justice Kennedy for a long time was the justice keeping this issue alive. So if he is gone and there's no longer that voice arguing to keep these cases alive and it's replaced with a justice who's more hostile, perhaps that results in a 5-block forming and saying we're just going to kick these cases out of court entirely. The court is probably shifting to the right. Again, we don't know exactly what's going to come out of these confirmation hearings. It looks like Judge Kavanaugh right now will become Justice Kavanaugh. He doesn't have a redistricting record, but given that the issue, the way justices have come down on the issue has aligned pretty closely with their other kinds of rulings, and conservative justices tend to be more hostile to these claims. The court is probably moving to the right. So we're in sort of this uncertain period where it seems like there are paths forward, but the paths may be more difficult than they were before, and we need to kind of keep pushing to see where things go. But here's the thing. Even if we were to win here, there we go. As I said at the top of the hour, the courts can't do everything. I mean, one of the things with trying to attack extreme partisan gerrymandering is that you're only putting kind of guardrails in on the most extreme stuff, and you're letting other stuff happen. So even if the court gave us the rulings we wanted, it wouldn't fix everything about our maps. So what's happening now is that I think priorities are shifting somewhat, and there's more emphasis being put on litigation in the state courts, ballot initiatives, and then other kinds of legislative reform. The sense here is that the ball, in many cases, is kind of back in the hands of state legislatures, and it's back in the hands of voters. And we see many places throughout the country where true inroads are being made, particularly on the ballot initiative front. And hopefully what will happen over the course of time is that these 4 or 5 different factors, the federal courts, the state courts, citizen-led direct action or direct democracy, and then legislative reform efforts, both at the federal level and the state level, all kind of combine over the next 3 to 4 years to make the atmosphere for redistricting fairer, if not absolutely perfect. So we've got in the state courts, this is the Pennsylvania state court. So the Pennsylvania state court litigation was a huge win that led to a map being drawn that by all projections is going to be substantially fairer to everyone in the state. Florida was also a large win. Like as I noted before, there's still some vestiges in the current map of some unfairness, but it remade a substantial part of that map and created a map that has allowed for a legislature that is more accountable, or congressional delegation that's more accountable and responsive. And there's also a potential, like Justice Kagan's writings in her concurrence, even if they don't become a majority rule in the U.S. Supreme Court, could get taken up by state courts who find the analysis persuasive, and that could become the basis for a whole new movement in state courts. Ballot initiatives can also help chip away. This is the Michigan State House. The Michigan ballot initiative is probably the most exciting one that's going right now. The state's had a long history of gerrymandering. In the 2000s, the map was pretty gerrymandered. This decade, it became an extreme gerrymander. They needed something, I think, like 400,000 signatures to get the initiative on the ballot, and they ended up with something like 700,000. I was visiting Detroit and Ann Arbor last year, and I was approached 3 different times over the course of a 4-day period in different parts of the state. I didn't sign because I don't live in Michigan, but they were really working the doors and working the sidewalks to make this happen. It's overcome a few challenges in the courts to keep it off the ballot, and given the widespread public support, we're pretty optimistic that this is going to become a thing. Michigan's advocating for an independent redistricting commission that's sort of like California's, that would have mainly representation from lay people and not politicians, who are free from the conflicts of interest that kind of screw around with the mapping process currently. But there are also initiatives moving forward in Colorado and Utah that would create not citizen redistricting commissions, but commissions that are have politicians but are constructed in a way that would prevent one political party from kind of running the whole table in the process. So they would allow for a lot more transparency and also create some checks on partisan domination of the process. Ballot initiatives aren't available everywhere. They're only available in about 24 states. But if this is kind of like a big puzzle, you can take out 3 to 4 pieces right now with what we've got on the table, and that helps move things. Legislative reform. We can't always count on legislators. I mean, the whole issue we're talking about here is an example where legislators are drawing their own districts, so they have kind of like an ingrained, huge conflict of interest. And you would then wonder, well, why would legislators take steps to limit their own power? One answer, at least at the state level, may be that the party that extremely gerrymandered the maps this time around doesn't feel very confident that they're going to have the majority they need next time to gerrymander the maps. And they may even fear that the other party will get the majority or the supermajority that they need. And if they see that happening, they may want to come to the table and compromise. So there is some interest that the parties have now in kind of hedging against the future by hitting compromises over the next 2 to 3 years. The other thing is that Congress has the ability to step in. And one of the things that you hear repeatedly in the federal litigation from judges that don't want the courts to do anything is, well, can't Congress set the rules, at least for congressional maps? And that's right, Congress could do it. Now, whether the current Congress would want to do that is another question. I mean, the story of the 2010 extreme gerrymandering wave was, although Democrats did it too, particularly in Maryland, there was a very well-coordinated effort that involved not just state Republicans, but national Republicans, including leadership on the Hill, to maximize seats all around the country. So right now, while we have a House and a Senate that have Republican majorities, there may be limited opportunities to move forward. There are bills that are ready to go if the balance of power changes that could start putting in some new limits. One of those bills is being sponsored by Senator Bennett in Colorado. It's what we call a criteria bill. So it wouldn't require every state around the country to adopt the California model, but it would require them to adopt rules that look like the kind of rules that we would like to see in redistricting processes about who can participate, the order of things that you should consider while you're drawing your maps, giving people a right to sue if those rules are violated, and doing some other things about how the maps can be fixed if they are found to be illegal. So that would also, in part, solve this problem. You wouldn't have to ask the Supreme Court to, divine some hidden wisdom in the Constitution to figure out when maps are unconstitutional. You just need to point to a statute that Congress just issued and say, Section 8 has a cause of action. It says you can sue if the following happened, redraw the map. So, yes, while it would ultimately help to have the Supreme Court step in here and put those limits on extreme things, we still have room to maneuver with or without action from the court over the next year. That being said, some action from the court this year would be great. I think that's my understatement of the day. That is about the end of the presentation. If you'd like to learn more, my colleagues and I at the Brennan Center, we now have a team of 8 people who work on redistricting basically full-time. We've put out a series of reports over the past 2 years. We're really working the extreme branding, extreme maps, and extreme gerrymandering. These reports, the second one is where all the charts that I pointed out earlier came from. They're available online to download. And then this is our website and our handles on Twitter. And thanks for talking with me, and I'm happy to.
Stay here because Tom will answer questions.
All right. We'll start in the back. The polisher.
Can you talk about the history of voting systems? How were we drawn before all this social engineering and supercomputers and all that? Pre-1950, how do we actually determine this?
Yeah. So this is a point that also comes up a lot in the court cases where people will say, hasn't gerrymandering been going on forever? So why would we stop it now? The original gerrymander was named after Elbridge Gerry. And that was from the early 19th century. A lot of the redistricting that was happening before the era of computers and voter data was being driven mainly by just the local knowledge of the legislators and the other kind of party bosses that were creating the map. So they would kind of have a rough feel for different pockets of the state where they had more or less support. And then it was basically a pencil and paper process of kind of combining those intuitions and experiences with pretty roughly drawn maps. What that meant was a couple different things, like they generally weren't as effective as they have become now, and they weren't as systematic. So in order to have a gerrymander that is really, really super durable, you need to be able to drill down to the precinct level and draw your lines like that precisely. And this is something that's been pointed out by some of the social scientists who've been working on the issue now. There's a method for identifying an extreme gerrymander where someone will take the existing map and they will run it through a computer and just make minute changes to the district lines. Like they'll put one precinct in and one precinct out here, and then change a little thing over here. They call it perturbation, but basically it's almost like shaking the map. And what it shows is, in these extremely gerrymandered maps, if you switch one precinct here or there, suddenly your advantage like collapses. And so you're allowed through current technology to get like that extreme precision you need to make a 10-3 map that holds the whole time. Before then, that just didn't happen. And next.
Okay, there's a couple. Does Florida have the right to have a ballot to change this, like Michigan's going to do? And
Yep.
that's, if you have so many people sign a petition and then it's on a ballot, I mean, then there's a vote in Michigan in November.
Yes.
And
Yeah.
then,
So,
and
yeah,
how is something like that worded on a ballot?
Yeah, that's well. So Florida has a constitutional amendment procedure, and that's how the legislation, or not legislation, but the constitutional amendment that shaped the mapping for 2010 was passed. The wording of these initiatives ends up becoming complicated, and was something that was litigated in Michigan because you need to be able to give voters an accurate sense of what they're voting for. I'm not totally keyed in entirely into the specifics of that process in any given state. But generally what ends up happening is, in addition to the petition drives, there's a large educational initiative that's kind of layered in around it that helps voters get a fuller sense of what this legislation, not just what the legislation does, but how it does it. Because generally the how is not outlined on the initiative, it's just the what. Creating fairer maps, but if you're going to pass a whole statute, you don't put the whole statute on the ballot. In the back.
In the North Carolina case, correct me if I'm wrong, but I understand that the recent ruling was to go back and change it before the election. If they were told, do this, you got to change it now before this election. Is that correct?
It's close. Things have changed a lot over the last 4 to 5 days. So what happened initially, the North Carolina case had been ruled on earlier in 2018, just in time for the defendants in that case, the legislators who were out there saying, we're going to gerrymander and there's nothing you can do to stop us, filed an appeal with the Supreme Court. It was waiting for the court to take it up while the court was deciding the Wisconsin and Maryland cases. The court decided the Wisconsin and Maryland cases and said, tell you what, we just issued these big opinions. Why don't you, district court, take your opinion back, reconsider it in light of what we've done, and then issue a new ruling. The North Carolina court, just about 3 weeks ago, I guess at this point, issued that new ruling. And what it did was it said, first of all, there should be no more using the current 2016 map in elections after 2018. And then it left open the question about whether the map could also be used for the 2018 election. What then ended up happening was it invited briefing from the parties, and even the plaintiffs stepped in and said, we don't think that this map should be redrawn for the upcoming election because it's just going to create too much chaos. So what that has avoided is a situation where the district court might have decided that it wanted to move forward with redrawing the map. Then the defendants went back to the Supreme Court, and then the Supreme Court 3 days later said, no, you have to go back to using the 2018 map. So it avoided some potential confusion on that front. Now what's going to happen is the court's not going to order the map to be redrawn for the 2018 election. It's going to let the Supreme Court appeal play out. The thing with all of that was what's been going on in North Carolina as far as gerrymandering is part of this kind of just larger collapse of like a functioning democratic government in that state. The norms of governance have gone completely out the door. And so you've had a series of kind of rolling or cascading democracy issues in that state that are all oriented around a legislature that secured a supermajority kind of fortuitously in 2010, kind of seeing that its time is up and doing everything it possibly can to insulate itself from getting voted out. And partially what the district court, I think, was reacting to in its opinion was, you're telling us that it's absolutely important that we have consistent primaries, but you've canceled primaries, and you've told us one thing and you've done the other. And so you've kind of vacated any claim you have to be a legitimate participant in the redistricting process, and the court was pretty angry about that. So it ended up backing down, but yeah, it's clearly that ruling was part of this broader political fight that's been going on in the legislature, between the legislature and the executive and the courts versus the legislature. It's been a total mess.
I had a question. I mean, everybody agrees that the Rorschach tests are ridiculous, and I heard somebody say contiguous zip codes. But you were saying when you have these models and one precinct can change everything, did you ever look? Because I'm sure from place to place, zip codes would matter greatly, something like that would work.
Yeah,
it's simplistic.
Well, it's, I think as with all of this stuff, it ends up being complicated. When I was talking earlier about redistricting being a political situation, and then also questions about, well, what would a fair map be? I think the answer is that the range of fair maps is actually really broad. And the more diverse your state is under any number of dimensions, the range of things that could be fair get bigger. And then the question is, how do we set up a process that allows us to pick one thing out of the whole range that we can all recognize as fair? One of the answers that the commission system has put into place is, well, if you create a system where everyone is confident that there are no conflicts of interest and everyone can participate and the deliberations are transparent, that creates faith that whatever comes out of the process is something everyone can accept. With district shapes, it's kind of no different. So among the things that you want to make sure that you can do, and sometimes contributes to strange-looking districts, is ensuring that racial and ethnic minorities in the country that have traditionally been had their voices minimized have an opportunity to participate. And in order to create districts that allow that to happen, sometimes the district shapes become less compact. So an example of that is what's called the earmuff district in Illinois, which kind of loops around a couple different parts of Chicago. And that's a district that was drawn to give Hispanic voters an opportunity to elect representatives that they feel are advancing their interests best. If you had to draw districts that were normal shaped, what you'd end up doing is taking a very large group of Hispanic voters and cutting them up between multiple districts. And so the legislature or the congressional delegation would never truly represent the true strength of their voice within the community. So whenever you see strangely shaped districts, it's always important to ask the question, well, why does it look like this? Sometimes it looks like that for bad reasons, sometimes it looks like that for good reasons. So you really want to get a handle on all of the things that influence the decisions in the redistricting process, which again is why transparency is very important. We don't get enough of it. And so, yes, sometimes when I see weirdly shaped districts, it might be, they're doing this to loop in a pocket of Democrats over here to make a Democratic district that shouldn't exist. But the context matters a lot.
There exists extreme disparity in the size of districts and for the U.S. House between 500,000 and more than 1 million. Is there anything percolating through the courts that would eventually overturned the Permanent Apportionment Act of 1929 that set the number of House members at 435 based on the 1910 census, so that we can actually shrink the districts and have less gerrymandering?
Currently, none that I'm aware of. But that does tap into a bunch of other things that are happening to try to alter the relative sizes of different districts vis-a-vis each other, including movements now that are popping up, particularly in Alabama, to try to not count non-citizens in the population bases, which would have the effect of shrinking certain areas and increasing the size of others. So there are people through various angles and from different approaches who are all trying to get at that issue, but as far as a direct challenge to the provisions that we were talking about, no, not that I'm aware of.
What would happen to gerrymandering, which I believe is just a blatant rigging of the election, when we finally get a national popular vote passed? How would that affect it?
I don't think it would affect gerrymandering because you would see, I guess actually I haven't thought about this much, but my initial instinct is that it probably would not affect gerrymandering because you wouldn't have statewide races for districted elections. So as long as your elections are districted in some way, there's still going to be an incentive to shape the lines.
A couple of questions. First of all, just a clarification. You said that one of the concerns the Supreme Court had was getting an avalanche of cases.
Right.
Does that mean that when a district court decides a case in this, the Supreme Court has to take it? I mean, they have a choice of not taking it.
Okay. Yeah. So did everyone hear the question?
No.
Okay. So the question was, when I was talking about the Supreme Court being afraid of an avalanche of cases, was the court required to take any of the appeals it gets from the districting cases, or could it choose not to? Normally, when cases come up the normal way, it's through the certiorari procedure. The court can opt to take it or not. And if the court decides not to take the case, it means nothing legally. The lower court, the appeals court's ruling stands, but you don't gain anything as a litigator by saying, oh, and also the Supreme Court decided not to take the case. In the redistricting cases, the court has to take the case. It doesn't necessarily have to take it for argument, but it has to rule on it in some way. And so there's been created this kind of body of Supreme Court guidance on what to do with those cases that basically say if the court affirms a case or reverses the case without actually providing an opinion explaining its reasoning, then that means that the court endorses the outcome, but not necessarily the reasoning behind it, which is super confusing. Even I don't understand that entirely. People fight over this all the time. There have been a couple of cases like that, like a case called Cox v. Larios. That was a redistricting case that's cited sometimes, and then inevitably there will be these huge footnotes where the parties argue about what Cox actually means because it was just a summary opinion. But yes, this creates this additional issue where the court doesn't want to be basically forced to issue either huge opinions explaining every decision it makes, or issuing hundreds of opinions that like have no reasoning behind them that then people will try to fight over and use for their advantage.
My other question was whether the Shelby decision on the Voting Rights Act has had, decimated the Voting Rights Act in any respect. Has that had any impact on the situation?
That's a good question. So the second question was whether the Shelby County decision, which basically shut down Section 5 of the Voting Rights Act, has had any effect on redistricting. The answer is mainly no, not yet. So Shelby County was issued in 2013. That was after most of the districts were redrawn, with some exceptions like Florida we saw. So this upcoming redistricting process is going to be the first time that maps are drawn throughout the country without the protection of Section 5 of the Voting Rights Act. Not to get super technical, the benefit of Section 5 is basically it said, if you're a jurisdiction within certain areas that have had a history of racial discrimination, then you need to send your plans to DOJ to get reviewed before you can enact them. Shelby County said the formula for figuring out what jurisdictions had to do that was outdated. It eliminated that, so now there's no Section 5 preclearance anywhere. that is huge for a couple of reasons, but one in particular is that states not wanting to even run the risk of getting their maps rejected were basically forced through Section 5 to try not to gain their maps. They couldn't afford to spend 6 months working on it, send it up, get it back 6 months later, and have it invalidated. But the other thing is that, I know at the Brennan Center, a lot of the analysis that I've given today has been kind of at the state level. And I think that when state maps are being redrawn, there's always kind of a natural, very large constituency of people, including many of the folks in the room here, who will care about that and be able to monitor it. But state maps aren't the only things that get redistricted. School board, county or city school boards, utility districts, all of these more local systems where there are redistricted or districted elections would also be subject to Section 5, and now they're not. And so the resources that it would take to monitor all of this and determine when maps are being manipulated, that task is going to become a lot harder. And it's going to require a lot more cooperation between groups that are involved in state level matters and groups that are involved in local matters. It's going to take a lot of communication and then also a lot more resources to challenge these things. It's going to take more resources to participate in these localized redistricting processes to try to fend off the likelihood that the maps get skewed in some way. So the loss of Section 5 has been big, but it's kind of like the true severity of the loss I don't think is going to be clear until 2022 when we see the maps that come out of this. I think I was looking at it.
Do you not think personally that the rationales given by the justices for striking down Section 5 was totally naive? It seems like what we've learned since then is that probably what we really need is Section 5 applied across the entire country at this point. Before it was just targeting a limited number of states.
Yes, the Shelby County decision was deeply misguided, and it seemed like it was guided from just a fundamental misunderstanding of what's going on. I think Justice Kagan summed it up best, or maybe it was Justice Ginsburg. I think it was Justice Ginsburg said, the ruling today that basically we don't need this protection anymore because America has become less racist is like saying throwing away your umbrella in a rainstorm because you haven't gotten wet. And yeah, that's basically the situation that we're in. And there's now a movement to revive the VRA. Yes. You have a booster on the side there, right?
I would think that there is some level, some assumption in the models of people pretty much staying where they are. And I wonder if there's any evidence that that level of mobility may be changing, say, with millennials who are more likely to move around with the aging population, with factories closing, any kinds of things like that, that might change that.
Yeah, I mean, what's interesting, there are a couple of things that are interesting about the what social science can help us see about these things, and one is that despite the fact that there is a large contingent of people who identify as independent, at least formally, most people vote either Republican or Democrat pretty reliably, and that if you know someone's party affiliation, you know, like, with almost absolute certainty how they're going to vote, which has enabled a lot of this gerrymandering to happen. But the other thing is, even with these fairly large shifts in where people are living, the maps have been so precisely engineered, and like the predictive quality of what they've been doing is so high that it's not changing outcomes. A related thing, this is not quite the issue you raised, but a related thing is that there is sometimes a belief that Democrats cluster in cities and Republicans are kind of spread out in rural areas, and therefore there's a kind of natural gerrymandering that occurs. And a very funny thing about states like North Carolina, like these true like battleground purple states, is that partisans for either party are spread fairly evenly throughout the state, and it's that even distribution that lets you get an extreme gerrymander, because it allows you to like very subtly change the boundaries to really maximize one party and minimize the other. And so there's like a complex political demography here, but people have gotten so good at reading the maps through voter data that they've been able to like neutralize basically all of it.
Florida is unlike North Carolina in that regard, because in Florida it would be very difficult to create a representative legislature without having people move, Democrats move out of the cities into Utah Junction.
There's a social scientist who's involved in a lot of these redistricting cases named Joey Chen. He's based in Michigan. He's done some analyses of the Florida map. And generally what he's found is that there is a kind of artificial bonus under the older congressional maps that Republicans were receiving. So it's not always the case that maps can be redrawn to create a directly proportional legislature, and there are some states where there is, because of clustering and some other thing, a tendency for one party or another to have more of an advantage. The question is whether that advantage gets exaggerated or not. The way the social scientists will illustrate this is they will create like a million maps, simulated maps of a given state, and then they run elections under each map. And they say, well, what would the outcome be under each of these millions of maps? And then they create a distribution. And it usually shows that for most states, the distribution is more or less equality between the parties, but there are some states where it's kind of shifted a little bit to the left or a little bit to the right, and the question is why, and the answer is usually something about the geography of the state.
I'm concerned. I mean, for me personally, I have no confidence in the courts because it is so partisan. I mean that, like, within a state, because of gerrymandering, the governor can appoint. Right. And I even look at the Supreme Court, if you look at Merrick Garland, the president that's under, I mean, go through the whole mess. Right. And at the Supreme Court, from what I understand, the Constitution does not say 9 justices on there. Let's even it out in a fairer way of deciding that isn't so partisan. Is there anything possible?
Well, so, I mean, I think that there are a couple of things. So most redistricting processes in the country involve input from both the legislature and the governor. And we saw extreme gerrymanders in states where both the legislature and the governorship were held by the same party. Or in North Carolina, the governor can't veto plans and Republicans control the entire process. And so the politics or the political nature of redistricting can actually be put to your advantage as a voter if you have split control. So if you have a legislature of one party and a governor of the other, you can use that political tension to actually neutralize the ability of one party to maximize its seats, because the governor won't like that and he'll just veto. And so the political process does have these kind of compromise points. The second thing is that this manifests itself more at the state level than the federal level, but it's something that came up in Pennsylvania, which is when one party creates these kinds of supermajority situations through gerrymandering, they create a legislature that usually ends up becoming very aggressive, and that aggressiveness starts to threaten the judiciary. So in Pennsylvania, after the Supreme Court said, this map's unconstitutional, it needs to be redrawn, there was a movement in the legislature to impeach all the judges. And similar things have happened in North Carolina. And I think that for judges, in states where they're elected, they have party affiliations, but they also have their own commitment to their own power and the integrity of their courts. And when that situation comes into play, it's like the politics of being a judge can also be a guard against extreme political actions by the legislature, because judges don't want to lose their power either. And so even though there is a lot of partisanship in the process, there are aspects of that partisanship that, if they line up in the right way, can actually be used to kind of push back too. So
Supreme Court, they can't lose their jobs.
It'd be interesting to see what would happen if the Supreme Court became in open conflict with Congress or the executive. But I think there is a definite concern, as I noted earlier in Chief Justice Roberts' situation, to make sure that voters perceive the court as being legitimate, because ultimately its power comes from people viewing it as legitimate and supporting its rulings. And so any kind of judicial decisions that would undermine that and throw that into question. And so that's another aspect of this institutional relationship or institutional interest that may help push back against what we're seeing from gerrymandering.
One last question. We really have to cut this off. You've been a great audience.
I'm just curious as to whether or not there's any discussion in the states that are looking at, redistricting, of using artificial intelligence and all, putting all those variables that we're concerned about and coming up with some ideal districts in these states. And we have the wherewithal to at least narrow it and get people looking for a balanced level.
Yes, with qualifications. So, and I think actually your comment did a good job at kind of bringing some of those qualifications into play. So, I think particularly over the last 2 years, there's been a lot of journalism that's spoken about kind of like tech fixes for gerrymandering, and the simplistic version of it is just turn redistricting over to algorithms and they'll make compact districts and that'll be fine and that's what we'll live with. The more complex one is what's being highlighted back here, which is, that first solution would be bad. In part because what we were talking about, the need, for instance, to empower communities whose voices are minimized. We frequently have to deviate from compactness in order to make legislatures that are really functioning the way they need to function. But what you can do is use these systems to specify a bunch of criteria that you care about, see what kind of different maps would satisfy it, and then have a public conversation about whether those maps advance those interests, as between those maps, which among them you prefer. And what that means is that there's now kind of a movement in social science and at the reform level to move these maps from like generating as many billions of maps as you possibly can to optimizing your maps and then creating situations where voters can basically like comparison shop between a couple of really concrete alternatives and then decide what they want. So yes, there's definitely a space for technology to assist that process, but it's never going to be able to replace it.
Thank you very much. I have a couple more things I want to talk about. First of all, if you're interested in gerrymandering, if you're interested in voting rights, come to the Voting Rights Coalition. We will meet next on Thursday, October 4th at 2 o'clock at Compass in Lake Worth. Second of all, you all know that there will be many ballot amendments on our 2018 ballot. Linda is co-chair of the Voting Rights Coalition with me, and she is also state policy advocate for the National Council of Jewish Women.
I just want, as you know, this event today is part of our Why Courts Matter coalition, which involves the League of Women Voters, the ACLU, and the National Council of Jewish Women. And as Nancy indicated, we've been doing a number of these events, and this was a wonderful one today. So our next event, which will be sponsored by the National Council of Jewish Women, is on another very hot button issue. On December the 5th, so you can save your day between 5 and 7 in the afternoon, Hannah Shearer from the Gifford Law Center and to Prevent Gun Violence is coming in, and the topic will be the courts and the Second Amendment, a really important issue. So December 5th, between 5 and 7, you'll get more information about it in the Boynton Beach area, but I wanted you to hear that right away because that's the next issue. Thank you.